Something subtle happened before anyone called it a scandal. No sirens, no emergency language, just a small, almost invisible correction to the public record. A statement appeared. Then, just as quietly, it vanished. And that disappearance mattered more than the words themselves. This story didn't begin with the release of documents. It began with timing, with the kind of reaction that doesn't look emotional, doesn't look chaotic, but feels hurried in a very specific way. The kind of move you make when you realize that the ground under a long-rehearsed position is no longer solid, when the reflex to speak collides with the instinct to erase. On the surface, nothing dramatic was supposed to happen. A federal court unsealed a large batch of previously sealed material tied to an old civil case connected to Jeffrey Epstein. Not a new investigation, not new charges, just paper finally seeing daylight after years in the dark. Depositions, exhibits, statements that had been sitting in archives untouched, legally inert, waiting for a judge to decide that silence no longer served the public interest. That decision alone should have raised questions. Courts do not unseal quietly sensitive material without reason, but most people miss that part. What drew attention was the response, or rather, the adjustment to the response. A public denial appeared almost immediately, framed as expected, familiar, procedural. The language followed a known pattern: dismiss, distance, rewrite the past in broad strokes. Nothing unusual there, except it didn't last. Hours later, the post was gone, not clarified, not softened, removed entirely, as if it had never existed. That's where the discomfort begins, because denials are cheap. People issue them every day. They leave them up even when they're wrong, especially when they're wrong. Deleting one is different. It suggests a second calculation has occurred, a recalibration behind closed doors. And from a legal perspective, that recalibration is rarely about optics alone. At this point, the details start to matter more than the headlines. The documents in question are not gossip, not social media claims, not anonymous accusations. They come from sworn testimony tied to a defamation case involving Ghislaine Maxwell. The case itself ended years ago, but the evidence never disappeared. It was simply sealed, protected from scrutiny while the public narrative condensed into something vague and manageable. Epstein knew powerful people. Everyone knew him socially. End of story. But the sealed material was never that generic. It contains names, locations, dates, overlaps that look trivial until you put them together. References to properties, to gatherings, to moments in time when the abuse described elsewhere was not hypothetical, not historical, but ongoing. And when those references re-entered the public domain, they created a problem that no amount of broad denial could easily smooth over. This is the part they usually keep quiet about. Courts don't ask whether something is comfortable to release. They ask whether withholding it still makes sense. When a judge decides that transparency outweighs privacy, it means the material carries weight beyond embarrassment. It means accountability has entered the equation, at least procedurally. Now add the reaction back into the picture. A person known for never retreating from confrontation, for doubling down even when advised not to, suddenly chooses erasure, not silence, erasure. That's not a media instinct. That's a legal instinct asserting itself late and a little too abruptly. Why erase a defense unless the defense itself creates exposure? Why remove your own words unless those words introduce risk? At this stage, no conclusions are necessary. The system hasn't accused, no charges have been filed, no findings announced. But the sequence is there, clean and chronological, and it's hard to ignore. Documents unsealed, a response issued, a response withdrawn, and somewhere in that gap, something shifted, not publicly, internally, the kind of shift that doesn't announce itself but changes how every next move has to be calculated. And this is where the story becomes uncomfortable to follow. Because once a system notices hesitation where confidence used to be automatic, it starts paying closer attention. And it doesn't stop just because the post is gone. The hesitation doesn't exist in isolation. Systems don't react to words, they react to patterns. And once that pattern appears, it starts pulling other elements into alignment, whether anyone wants it to or not. At this stage, the question is no longer what was said, but what the deletion forces everyone else to do next. From inside a legal mechanism, a deleted statement is not silence, it's movement. It tells you that counsel intervened, that risk was identified after the fact, that the initial instinct to dominate the narrative collided with something less flexible than public opinion. Law doesn't care about tone. It cares about exposure. And exposure increases when your own timeline begins to contradict itself. This is where the mechanics become visible. Prosecutors don't build cases on outrage. They build them on proximity, access, knowledge. You don't need to prove that someone committed the central crime to move forward. You need to show they were close enough to know, positioned well enough to see, embedded deeply enough that ignorance becomes implausible. That's how larger cases are assembled piece by piece, long before anyone uses the word indictment. The unsealed material does exactly that kind of work. It doesn't shout, it situates. It places names in rooms on properties within calendars that overlap with periods already established as active. On their own, these details look small. Combined, they start to resemble infrastructure. And infrastructure is what allows systems to function quietly for long periods without interruption. The deleted post amplifies this effect, because now there's behavior to analyze alongside the documents. Not testimony, not accusation, behavior. And behavior is often more reliable. When someone adjusts their public position after legal review, it suggests that the original position could not withstand scrutiny. That doesn't prove guilt, but it establishes awareness. Awareness is a threshold. Once crossed, certain defenses become harder to maintain. This is the point where narratives usually fracture. Public discourse wants absolutes. Law works in gradients. The documents don't claim everything, they don't need to. They introduce enough structure to support further inquiry, and once inquiry begins, control over pacing disappears. The system stops asking for permission and starts requesting compliance. There's another layer that rarely gets discussed. Epstein is no longer a variable. Maxwell is already contained. That removes unpredictability. What remains are connections, corroborations, and incentives. When central figures are gone, pressure doesn't dissipate. It redistributes toward those still exposed, toward those with reputational capital left to lose. At this point, defenses based on office or immunity weaken. The conduct described does not sit neatly within any single term or role. It stretches across time. That matters procedurally. It opens pathways that are normally blocked. It complicates arguments that rely on institutional shielding. And here's where the system usually fails people who underestimate it. They assume that because nothing has happened yet, nothing will. But investigations don't announce themselves at the beginning. They announce themselves when they're finished. Everything before that looks like paperwork, silence, and small, inexplicable adjustments in behavior. The deletion wasn't panic, it was recognition. Recognition that the environment has changed, that previous strategies no longer apply cleanly, that speaking freely now carries a different cost than it did before. And once that recognition sets in, every future move becomes slower, heavier, constrained. Because the real danger isn't what has been released. It's what the release allows next. And at this point, the system is no longer reacting to noise, it's watching structure. Now, the story enters a zone where intent matters less than consequence. Not what anyone meant to do, but what can no longer be undone. Once a system has adjusted its posture, it doesn't return to neutrality. It proceeds even if quietly, even if slowly, even if no one confirms it out loud. The documents are public. That alone changes the terrain. Public doesn't mean proven. It means usable. It means cross-referenceable. It means every future filing, every witness interview, every unrelated inquiry now has an expanded context to operate within. What once required a justification to access now requires only a reason to connect. This is where risk compounds, not explosively, but procedurally. Timelines harden, gaps narrow, inconsistencies that were once rhetorical become evidentiary, and the earlier deletion meant to reduce exposure becomes a fixed point in that timeline. A moment where awareness can be argued, a moment where strategy visibly shifted. At this stage, the system doesn't need a headline event to move forward, it needs patience. Investigations that matter are rarely loud at the beginning. They surface later, fully assembled, when denial no longer functions as defense and silence no longer reads as restraint. There's also a broader failure unfolding in parallel. This case isn't isolated from everything else surrounding it. Legal pressure stacks, separate matters start sharing oxygen, resources thin, attention divides. And when that happens, mistakes follow. Not dramatic ones, small ones, procedural ones, the kind that don't look dangerous until they accumulate. The most destabilizing element is uncertainty. No one involved knows which thread will be pulled first, or whether it already has been. That uncertainty alters behavior. Communications tighten, public language flattens, risk tolerance drops, and the very instincts that once projected strength begin to signal containment instead. This is what a point of no return looks like in real time. Not an arrest, not an announcement, but a narrowing of options, a future where every response is constrained by something already on record, where the past cannot be rewritten fast enough to stay ahead of the present. What happens next doesn't depend on outrage or belief. It depends on process, on whether the system continues doing what it is designed to do once certain thresholds are crossed. And those thresholds, once visible, don't recede. The story doesn't end here, but it no longer belongs to the person at its center. It belongs to the machinery now in motion and to the consequences it produces without asking whether anyone is ready for them. What makes this situation structurally different from earlier controversies is not the subject matter, but the procedural environment surrounding it. The legal ecosystem in which these documents surfaced is far less forgiving than the political arena where similar stories once dissolved into noise. Civil filings, sealed testimony, judicial orders to unseal, these are not symbolic acts. They are mechanical ones. And once initiated, they generate downstream effects that cannot be controlled by public messaging. One of those effects is secondary inquiry. When material becomes public through a judicial process, it invites parallel scrutiny that does not require coordination. Civil litigators revisit old cases. Journalists cross-check sworn statements against travel records and contemporaneous reporting. Prosecutors assess whether previously dormant threads now meet evidentiary thresholds. None of these actions require a central decision. They happen because the material exists and because ignoring it becomes professionally risky. Another overlooked element is how testimony ages. Statements made under oath years ago gain new meaning when viewed alongside later behavior. Inconsistencies that once seemed irrelevant take on weight when they intersect with a visible change in strategy. The deletion of a statement is not just a moment. It reframes everything said before and after it. It invites a retrospective reading of prior denials, prior interviews, prior sworn answers. That retrospective process is where many cases quietly mature. There is also the question of leverage. High-profile investigations rarely move in straight lines. They apply pressure unevenly, often indirectly through peripheral actors, former associates, staff, legal intermediaries. People who were once irrelevant become relevant because they sit between timelines. Once documents are public, those individuals know that their own exposure is easier to establish. Cooperation becomes a rational choice long before it becomes a public one. Institutional memory plays a role as well. Offices like the Southern District of New York do not forget material simply because time passes. Files remain accessible. Context accumulates. A document unsealed today can resurface years later as corroboration for something entirely different. This is how long-form accountability functions, not as a single dramatic case, but as an archive that grows more usable over time. Another factor rarely acknowledged is reputational insulation. For decades, proximity to power functioned as protection. That assumption has weakened. Courts have become more willing to treat prominence as a reason for scrutiny rather than immunity. Judges, in particular, have shown less tolerance for arguments that rely on status instead of substance. The unsealing decision itself reflects that shift. It signals a recalibration in how harm, privacy, and public interest are weighed. And then there is the structural absence at the center of this story. Epstein's death closed off one avenue of inquiry, but opened another. Without a central defendant, investigations tend to broaden rather than narrow. Responsibility diffuses outward. Patterns replace individuals. That is often when systems become more dangerous for those who assumed the story ended with one name. All of this unfolds without urgency. That is the unsettling part. There is no race, no visible escalation, no public countdown. Just an expanding field of relevance. More documents, more cross-references, more incentives for others to protect themselves preemptively. What looks like stagnation from the outside is often consolidation on the inside. When systems stop reacting emotionally, it usually means they are reorganizing analytically. And once that reorganization is complete, outcomes arrive fully formed, leaving very little room for improvisation. At this stage, the most consequential developments are the ones no one can see yet, not because they are hidden intentionally, but because they have not been triggered. And in systems like this, triggers are rarely dramatic. They are procedural, a filing, a motion, a subpoena that doesn't make the news. By the time the public notices movement again, the direction is usually already set.